Thursday, June 18th was supposed to be another routine day in a legal battle that has already consumed headlines for months. Another hearing. Another round of arguments. Another day of motions filings and courtroom strategy. That is what everyone expected when attorneys entered Courtroom 4B inside the United States District Court for the Southern District of New York. What happened instead sent shockwaves through the courtroom and instantly changed the trajectory of the entire case. At exactly 2:17 p.m. Eastern Time, Trump's lead defense attorney David Kessler stood before Judge Patricia Navarro and made a statement that seemed ordinary on the surface. Speaking under oath, Kessler addressed questions regarding the handling of sealed evidence, specifically a document identified as Exhibit 14C. His statement was direct. According to Kessler, no member of the defense team had accessed Exhibit 14C before the official discovery disclosure date. Simple. Clear. Unambiguous. For a few seconds nobody reacted. Then Judge Navarro reached into a binder sitting directly in front of her. Inside that binder was a document that would change everything. The Exhibit Access Log. A record already entered into evidence weeks earlier. A record carrying timestamp security credential signatures and access history. And according to that log, David Kessler himself had personally accessed Exhibit 14C nearly a month before the date he had just provided to the court. His name was there. His badge number was there. His signature was there. The courtroom suddenly became silent. Not ordinary courtroom silence. The kind of silence that happens when everyone in the room realizes something has gone terribly wrong. Court reporters stopped typing for a moment. Attorneys looked up from their notes. Observers leaned forward. Even veteran journalists who spend years covering federal courts later described the atmosphere as electric. Judge Navarro looked directly at Kessler and asked a simple question. Would he like to reconsider his statement? At that moment there was still an exit. There was still an opportunity to clarify. There was still a chance to explain. But according to courtroom accounts, Kessler did not retreat. Instead, he reportedly suggested the access log itself might be inaccurate. That answer only deepened the problem. The judge already had the record. The document had already been authenticated. The signature was already part of the case file. This was no longer a dispute about interpretation. It had become a dispute about facts. And the facts were sitting directly in front of the court. Within minutes the hearing stopped. The normal rhythm of courtroom proceedings disappeared. What followed moved with extraordinary speed. Emergency discussions began. Court personnel moved into action. Federal marshals were notified. Legal observers who have spent decades covering federal proceedings described the sequence as almost unheard of. Most contempt matters take days. Sometimes weeks. Briefs are filed. Responses are submitted. Hearings are scheduled. But this situation unfolded differently because the alleged contradiction was immediate, visible, and already documented. The evidence was not hidden in thousands of pages of records. It was sitting in the judge's binder while the statement was being made. By the afternoon, an emergency contempt order had been prepared. Shortly afterward, federal marshals escorted Kessler from the courtroom. The images immediately spread across newsrooms, social media platforms, and television broadcasts. For many Americans, the moment was stunning. Not because attorneys never face consequences. They do. But because lead attorneys in major presidential cases rarely find themselves at the center of the controversy. Usually the focus remains on the client. This time the spotlight shifted directly onto the lawyer. And that changes everything. David Kessler was not simply another attorney on the defense team. He was the central figure coordinating legal strategy. Major motions carried his signature. Important filings passed through his office. Critical decisions often required his approval. His removal created an immediate vacuum. Questions emerged instantly. Who would take control of the defense? Would existing legal strategies remain in place? Would previous filings be reviewed? Would the court examine earlier representations made under Kessler's supervision? Those questions quickly became the dominant discussion among legal analysts. But the story becomes even more significant when you examine the weeks leading up to Thursday. Because according to court records, this confrontation did not appear from nowhere. The warning signs had been building. Weeks earlier, prosecutors raised concerns about inconsistencies involving document access and discovery procedures. Judicial warnings followed. Requests for clarification followed. Additional filings followed. Each step increased pressure. Each filing narrowed options. Each warning moved the parties closer to confrontation. Judge Navarro's record provides important context. Over more than a decade on the federal bench, she developed a reputation for patience combined with strict enforcement. Attorneys familiar with her courtroom often describe the same pattern. She warns. She documents. She waits. Then she acts. Former clerks have repeatedly described her as a judge who gives lawyers opportunities to correct mistakes but reacts forcefully when she believes those opportunities have been ignored. That reputation mattered on Thursday. Because critics immediately attempted to frame the incident as political. Supporters of the court argued it was procedural. Supporters of the defense argued it was excessive. The debate began within minutes. But the court record itself became the center of attention. What did the document show? What exactly was said? What evidence existed? Those questions dominated legal analysis throughout the evening. Meanwhile, prosecutors found themselves in an unusual position. They did not need to make dramatic arguments. They did not need to file aggressive motions immediately. The courtroom events spoke for themselves. The defense suddenly faced challenges beyond the original allegations. Credibility became an issue. And in litigation, credibility is everything. Judges evaluate it. Juries evaluate it. Opposing attorneys attack it. Once credibility becomes part of the story, every future argument faces additional scrutiny. That reality is now impossible to ignore. Legal experts quickly began discussing possible next steps. Could prior filings be reviewed? Could earlier statements face examination? Could sanctions expand beyond one attorney? Could prosecutors request additional remedies based on what happened? Every possibility suddenly appeared on the table. Then came the political fallout. Television networks interrupted programming. Commentators filled studio panels. Supporters and critics raced to frame the narrative. Some argued the events demonstrated accountability within the justice system. Others argued they reflected broader political conflicts playing out through legal institutions. Regardless of perspective, one fact remained unchanged. A routine hearing had become a national story. And the consequences were still unfolding. Attention now turns to the next scheduled proceedings. The court must determine how to address the fallout. The defense must reorganize. Prosecutors must decide whether additional action is necessary. Political figures will continue responding. Media coverage will continue expanding. And the public will continue watching. Because moments like this are rare. A single statement. A single document. A single exchange between a judge and an attorney. Those were the ingredients. Yet within less than an hour they produced one of the most dramatic courtroom developments of the year. The legal battle itself is far from over. If anything, it has entered a more volatile phase. The questions are larger. The stakes are higher. The scrutiny is more intense. And every participant now understands that every word spoken in that courtroom will be examined more closely than ever before. Thursday began as another day on the calendar. It ended as a turning point. What happens next could determine not only the future of the case but also how this extraordinary chapter is remembered years from now. The courtroom doors will open again. The proceedings will continue. The arguments will resume. But after what unfolded on June 18, nothing feels routine anymore. The entire legal landscape shifted in a matter of minutes, and the consequences of that shift are only beginning to reveal themselves.